police officer?
I'm not a police officer. I'm an
Have you ever been a police officer?
Yes, I've been a police officer.
You have been a police officer?
Yes, you are.
Thank you so much. Paragraph 21. Now, paragraph 21, you're saying there are co-conspirators. Confirm?
Yes.
Do you know the co-conspirators by name?
That is part of the investigation. I cannot reveal it.
No, I'm just saying, do you know by name, not their names? Do you know them by name? Because you have said there are co-conspirators. Do you know them? Not by name.
Okay, she's not asking you to name them.
Counsel, this is what I've been saying. Relax, let me answer.
Let me help you to do that. Just say yes or no. Do you know the co-conspirators?
No. The matter is under investigation.
Yes or no?
As of now, no.
You don't know them. Thank you so much. Number 2. You have said that there was the man of the deceased plan executed and their attempts to cover up. Do you know the people who are trying to cover up the death of the deceased?
One of them is your client.
Do you know that with certainty?
Yes.
Have you provided evidence to that effect of the attempt to cover up?
It's an investigation but not attached to this agreement.
You have said yes, you know the client is one of the people trying to cover up. My question is, have you provided evidence that he is one of the people who is trying to cover up?
As of now, no.
No. Thank you. Thank you so much. Thank you, Honor. That will be all.
I think, Your Honor, that will be the end for cross-examination of the witness. We will lay down this. Once is discharged, this return will lay the basis for our next line of.
Even we would allow a few minutes of re-exam because that follows cross-examination. Mr. Gibbs,
Yes, Your Honor.
my work is to calm you down completely and make you smile.
Actually, I'm calm and composed.
I'm glad. Thank you. Now, I will limit my questions back to the contents of your affidavit, many times by paraphrasing. What is the basis of your request for detention continuing today in one line?
To complete my investigations.
On a scale of 0 to 100%, how much could you, by approximation, attach to your investigations up to now on a scale of 0 to 100%? Doesn't have to be accurate approximation.
49%.
49%. So I can mathematically say this as directly as that you're saying there is 51% of investigations to be done.
Yes, Your Honor.
So that there are questions about who is in charge of the cells, who is in charge of who is in command of the station. Do those questions relate to the remainder of your investigations?
Yes, they do.
Now, to ask another direct question, are the questions from the defense some of the things you need to investigate to complete your investigations?
Yes, Your Honor.
Thank you very much, Your Honor. I'll hand over to Mr. Johnson.
Just one question in the information. You have been asked whether you have attached any document relating to, I think it was paragraph 6A, some paragraphs in the affidavit, whether you have attached anything to show that even the respondent is
the flight risk, why do you need the respondent in custody? Is there any reason why you have not attached?
Yes, Your Honor, the reason I have not attached what I've collected so far, the 49% I'm talking about, is that it will jeopardize the and this actually to protect the integrity of the investigations. That's why we cannot divert much.
Thank you very much. I believe that is all from our end.
Thank you, Your Honor.
Then allow the next case of
They're bringing the video. How is it?
Now we consider check out 5 minutes.
Depends how.
As we are ready, we're only asking for the benefit of 4. There's Kiton, there's Langat, there's Tusi.
We are fine. We are fine. There are something that have been filed that can be served. There is a moral. Yes, very well.
We'll serve you with authorities. Simply. Our team serve the state together.
For the record, I remain Felix Kiton, and also there was another additional attorney at law, Vincent Diego, also is part of the defense team. Your Honor, we reiterate that we vehemently oppose the motion application dated the 16th of June 2025. And from this motion, Your Honor, there is only one salient issue for determination. That is whether there are compelling reasons for continued detention of the respondent. Your Honor, permit me latitude to lay the legal basis. It's a humble submission, Your Honor, that the issue of the question of pre-trial or pre-charge detention has been settled in law. It's well settled in law. And as such, Your Honor, Article 49(1)H and 49(1)G of the Constitution is very clear that an arrested person has a right to be released on bond or bail unless there are compelling reasons. Your Honor, in order to conceptualize and also problematize the issue, Your Honor, permit me to refer you to the statute, which is section 6A of the CPC, of the Criminal Procedure Code. And in order also to contextualize the issue, Your Honor, is that this section 6A was an amendment following the locus classicus in Michael Rotich, that is in Michael Rotich versus the Department of the 2016 decision, whereby, Your Honor, in this section, it lays the 2-tier threshold for such an application to succeed. The first burden, Your Honor, is on the investigation, that is the Ipoa. And the other also burden also, Your Honor, rests with the Honorable Court. And as such, Your Honor, under section 6A, it is very clear that pursuant to Article 49(1)(f) and (g) of the Constitution, a police officer shall present a person who has been arrested in court within 24 hours after being arrested. And now it lays now what the investigation officer must do. First, he must make an application in writing. First, he must produce the suspect in court, which they have done, which we admit that. Then the second thing, Your Honor, is that they must apply in writing, and they have done that through this motion application. But now, Your Honor, the greatest issue that they must also do, Your Honor, is that under section 36A clause 3B, it states that the investigation must also adduce the reasons necessitating the continued holding of the suspect in custody. So the question that begs our attention at this juncture, Your Honor, is whether there are reasons necessitating the continued detention of the respondent. And we submit, Your Honor, in negative, that the investigation have not adduced any cogent reasons necessitating continued detention of the respondent. And Your Honor, my learned friend, they have already gone through the cross-examination limb by limb in the entire affidavit. But if you may permit me only to refer you to 2 or 3 salient issues, Your Honor, in order to illuminate why this motion application is bereft of meat and substance to stand on. First, Your Honor, I would refer you, Your Honor, to look at paragraphs 9, 10, 11, and 20 of that. They are building a case that you should continue to detain the respondent because he's likely to interfere with the investigation. We submit, Your Honor, that that is not a cogent reason. And we'll invite you, Your Honor, to consider the authority which we have provided, that is Republic versus Mercy Chebet. It is a 2022 decision whereby Justice Igonyo has indicated successfully, and I will humbly refer you, Your Honor, to paragraphs 17, 18, and 19 of that decision, whereby the High Court has settled the law that for such a threshold to succeed, the investigation must tender material information to the Honorable Court to demonstrate the nexus link that is between the respondent and the likelihood of interference. And I will also refer you, Your Honor, to also adopt the reasoning of Justice Mutuku in Republic versus William Kitiri and Godfrey Kirui, whereby the same threshold.
Your Honor, this is not an objection. It's an humble plea that counsel shares the decision with us, and that it is generous enough that he also points out the paragraph that is paraphrasing, so that we are able to respond.
Your Honor, we have already filed our list and digest of authorities dated in 16th of June 2025, and you can confirm, Your Honor, that they are there. Decisions and everything, they are already coming. It's the last decision. Sorry.
I am looking at the document, sir. I am alert.
Thank you.
The document written respondents list and digest of authorities.
Yes, you are.
I am looking for Mercy Chebet. You have it in the list.
There is another one which is.
So it's not in the list.
No, it's the one you are holding.
Thank you. No, this is the list. It does not have Mercy Chebet. Does it have it?
You already have an authority, the one next to your phone.
You know what we are informing the court is that we didn't have it in the list. So it has added it, that's okay. That's what you're asking. So we can have the paragraph.
Authority, Honor. You have already defined it. Yes.
But I think
yes.
I have the Mercy Chebet.
Yes.
And I don't have the William one.
Yes.
Yes.
Yes. So, Your Honor, if I may.
Did you call for the William?
It appears there was an oversight, Your Honor, but I know the court investigation process of all the citation or all the authorities, if you have already provided the citation, Your Honor. Your Honor, he has interfered with the flow of my thoughts.
My apologies. My apologies. I am not in that business like my colleagues. They told that must tears.
So what you are saying, Your Honor, at paragraph 17, Justice Gigonyo has laid the threshold and also eliminated that interference with witness undermines the criminal justice system and dents the integrity of the criminal process. And he goes on and also says that for such a ground to succeed, the prosecution must tender or must present material information to the Honorable Court. And they had also a decision which we have also cited, Your Honor, the William Kikir case, whereby Justice also Mutuku said that there should be a nexus between the respondent and also the stated interference, Your Honor. So that was the main ground, Your Honor, that has been advanced at paragraph 9, 10, 11, and 20 of the affidavit. Another link, Your Honor, of the affidavit that, Your Honor, I will humbly beg to refer you to paragraph 24 of the affidavit, whereby you have been told, Your Honor, that the gruesome murder of the deceased has elicited widespread public anger and also leading to demonstrations, which at times have been destructive. Hence, the safety and security of the respondent cannot be at this point be guaranteed if released on bail. So in order, Your Honor, to demonstrate that such a reason, Your Honor, should not hold water is that we will humbly beg to refer you to the same decision of Justice Gigonyo, that is Republic versus Mercy Chebet, whereby at paragraph 20, which is also titled Safety and Security of the Accused Person, the judge lamented, Your Honor, at paragraph 21, that I have lamented time without number, and again, slide into grief. How and why in this age and time should people take the law into their hands to harm their accused? The community herein is within the territorial jurisdiction of the Republic of Kenya, a nation governed by law and order. And under the Constitution of Kenya 2010, I wonder whether the said community will derive the authority to harm or kill a suspect under trial. No one is above the law or should take the law in their hands. All are bound by the Constitution which reigns. And the community in question should let the law punish the accused. This should stop, and my view is that ground that the security of the accused is threatened by the members of the public or victim family should never, and mark my words, Your Honor, should never be encouraged to be a ground for denial of bail. Otherwise, the court will inadvertently promote or condone violence, disorder, and usurping of law by individuals or group of people. We say no more, Your Honor. Such ground should fail in limit. The court, the High Court, has settled the law on that. On the other hand, it is even the duty of the police also to guarantee the safety of the respondent. And you have also been told other issues, Your Honor, that they need time to do forensic, to subject the judges to forensic, etc., etc., etc. We submit, Your Honor, that all those reasons that have been given, it can be done without the need for any custodial order. So we submit, Your Honor, that from all the reasons that have been abused, none is cogent and none should pass the master of the law, because they have already done what they ought to have done, and any proposed investigations can be done without the need of subjecting the respondent to custody, Your Honor. Having submitted the link, Your Honor, that they have failed to demonstrate the reasons necessitating further or continued detention of the respondent, Your Honor, we submit on the second link, whereby their statute also, Your Honor, has also given the court the latitude or guidance on what should do. and we shall invite you, Your Honor, to consider section 36, clause 5 of the Criminal Procedure Code, whereby it is stated that a court shall not make an order for the remand in custody of a suspect under subsection 5 unless there are compelling reasons for believing suspect shall not appear for trial, may interfere with witnesses or the conduct of investigations, or commit an offense while on release. So, Your Honor, even having submitted that they have not abused that instrument, there is a duty that the court also must also satisfy itself before granting any custodial order, that there are compelling reasons that the suspect will not appear during the trial. And there is no such reason that has been advanced by the state, Your Honor. And the other aspect of interference, Your Honor, we have already submitted that there are no material information to persuade you that there is a need to further detain the respondent, Your Honor. And in doing so, Your Honor, on the duty imposed on the court in the 2-tier threshold, that is the threshold in the second tier threshold, which is the duty of the court, will invite you, Your Honor, to adopt the reasoning of Justice B.J. Otieno. That is a High Court decision in Ramadan M. Hassan versus DPP. It's a 2017 decision, whereby as paragraph 15 of that decision, Your Honor, it is at pages, we are finding that authority. It's at pages 43 to 46 of our bundle, whereby the judge reasons this way, Your Honor, that I must add that a judicial officer before whom an application is presented seeking to limit the enjoyment of a suspect's fundamental freedom akin to the right to liberty is duty bound and enjoined by law and the Constitution to be extra vigilant and not to interrogate whether the fact